we will start the session. So, Meenakshi, you can start the session. Hand over to you.
Okay, sir. Okay, sir. Good afternoon to one and all present here. I'm Meenakshi Sharma, currently pursuing my second year LLM at the Central University of Karnataka. I'm honored to serve as the moderator for this technical session. I warmly welcome you all to Technical Session 1A, Theme Global Perspective of Criminal Jurisprudence, conducted as a part of the International Conference on From Micronarrative to Meta-Narrative, Reimagining Criminal Jurisprudencia, Globalized World, organized by the Department of Law, School of Legal Studies, Central University of Karnataka. This session brings together scholarly insights on the evolving landscape of criminal jurisprudence in globalized context, from international criminal accountability to cybercrime in virtual worlds, and from technological narratives to environmental justice. The objective of this session is to foster deeper understanding and critical engagement with global and cross-border legal issues related to crime, justice, and enforcement. Now we are honored to have with us Professor Jeeva ma'am. She is a professor of Faculty of Law, University of Colombo, Sri Lanka. Ma'am started her academic journey in 1993 and has since held many prestigious positions at the university and national levels. Her career is marked by remarkable contributions. She was the head of the department, deputy director of the virtual campus, and has served on several governing and advisory boards in Sri Lanka. She was awarded the national honor of Deshabandhu by the Democratic Socialist Republic of Sri Lanka in 2019. She has played pivot roles in shaping victim and witness protections laws, criminal justice reform, and gender inclusivity in governance, including her appointment as the first female government director of the Colombo Stock Exchange. Her research span human rights, criminology, victimology, and justice system, and she has presented over 50 papers across esteemed global conference. We warmly welcome you, ma'am. We welcome you, ma'am. We are also pleased welcome our co-chairperson, Dr. Jayanta sir. He is Assistant Professor, Department of Law, Central University of Karnataka. Dr. Jayanta sir is an accomplished academic and legal research, currently serving as Assistant Professor in the Department of Law, School of Legal Jurisprudence Studies. He holds as a PhD in Law of Nahu with a specialization in Sustainable Forest Management, and is a gold medalist in both LLM and MA Sociology. Dr. Jayanta sir has published extensively with over 30 research papers, 15 books, chapters, and 3 internationally published books, one of which is translated into 6 languages. He is the founder of Equitance Victoria Foundation, has organized and judged numerous national and international academic events. I welcome you, sir. Now, with the permission of chairperson and co-chairperson, we will start the paper presentation. Shall we start, ma'am and sir?
Yes, please go ahead.
Yes, please.
Okay, ma'am. Before we begin, a quick note for all the paper presenters. Each speaker will have 8 minutes to present their paper. At 6 minutes, I will gently remind you that you have 2 minutes left to conclude. We kindly request to all speakers to adhere to the time limits in the interest of smooth coordination and to ensure that every presenter gets an equal opportunity to share their valuable work. All questions and discussion will take place after all the paper presentations are completed. Please ensure your microphone and cameras are working well. To begin with this session, I now invite Dr. Diwakar Sharma sir. He is an Assistant Professor, Mahapurusha Srimantha Sankaradeva Vishwavidhyalaya, to present his paper titled Selective Justice and International Criminal Court, a Study. Dr. Divakar, sir?
Yeah. Thank you, madam. Am I audible, madam?
Yes, sir. Yes, sir.
Namaskar. Namaskar, sir and madam and everyone present. I am Dr. Divakar Sharma. I'm an assistant professor working in Mahapurush Srimanta Shankardev Vishwavidyalaya, which has been set up in the name of Mahapurush Srimanta Shankardev, one of the great saints in Assam. So my paper title is Selective Justice and International Criminal Court Study. So before beginning with the paper, I want to draw the synopsis. That is, I'll be starting with some of the introduction, and I'll be going to the objectives, then research methodology, and then the concept of the selective justice in International Criminal Court. Then the ICC chooses the development of justice, where I have divided it into 4 subunits, that is embryonic, formation, practical, and regulatory stage. Then I'll be going with the factors influencing the selection of justice by the International Criminal Court, where I'll be discussing about the choice of legislations, the choice of the law enforcement authorities, and the choice of the country. And lastly, finally, I'll be concluding. Now, begin with the introducing the topic, the entry into the force of the Rome Statute. The Rome Statute is being the act that is being used by the ICC for adjudication of the International Criminal Court, and the establishment of the ICC is important symbol of the improvement and development of the international criminal law system. The international community has criticized the selective justice of the International Criminal Court, especially the African countries, which have expressed strong dissatisfactions. Now, coming to the objectives, the researcher has 2 objectives here: to study the judicial selectivity of the ICC and to study the legislative actions of the selective justice by ICC. Now, coming to the research methodology, the researcher has purely gone through a doctrinal method of the books, X, case studies, etc. Now, coming to the concept of the selective justice in the ICC, in the recent years, the selective justice has been directed at African leaders. So enforcement of the international criminal law has been more selective than enforcement by domestic courts. Selective justice refers to a system in which when a crime is committed in a country or a region, the judicial authorities will make different treatments according to its specific circumstances. According to the Chinese and foreign scholars, the selective justice of the International Criminal Court covers a series of selective acts, including both not limited to 3D making discretion, the UN Security Council, and the state contracting, etc., which have a certain impact on the operation of the International Criminal Court system. It refers to a set of rules and mechanisms based on the jurisdiction in the field of international law. In the international law criminal court, the discretion of the judges and the prosecutor leads to a selective judicial actions. Now, coming on to the International Criminal Court chooses to the development of justice. So now, coming to the first embryonic stage, the formation stage. At the end of the World War II, the establishment of the Nuremberg and Tokyo and the ICTY tribunals, as well as the Rwanda tribunal, injected targeted judicial suits into the field of international criminal justice. But prior to the Rome Statute and the subsequent establishment of the International Criminal Court, advocates of the international criminal justice were increasingly concerned about the judicial selectivity involved in the arbitrary selection of single conflict tribunals. Since these international criminal judicial bodies were established in the context of selective justice was seen in its infancy as a criticism, whether well-intentioned or ill-intentioned, and has been a difficult problem for the ICC for its inception to the present day. The main feature of the sprout of the selective justice is that it does not conform to the principle of neutrality and non-discrimination, which has become the biggest obstacle to its development. Now, the second stage, the formation stage, in 1994, the draft of the Rome Statute of the ICC was introduced. In 1995, the United Nations established the Preparatory Committee for the International Criminal Court. On 1st July 2002, 60 countries ratified the Rome Statute, making the International Criminal Court the world's first permanent international criminal institution responsible for enforcing jurisdiction over international.
Mr. Divakar, sir, your voice is not coming. You are not audible.
I think he is having some network issues.
Yes, sir, maybe.
How much time was left?
Sir, 4 minutes are left.
Okay. Let's move with the next presenter. If he can resume in the meantime, then we'll see about.
Okay, sir. Will be moved to next. We have a next presenter, paper presenter, Modi Umang Kumar Champaklal, Assistant Professor. He is an Assistant Professor, Faculty of Law, the Maharaja Saidji University of Baroda. He will present his paper titled Reimagining Global Justice, Contemporary Challenges and Transformative Perspectives of the International Criminal Courts. Mr. Modi.
Thank you. Thank you
You
for giving me
may begin.
opportunity to speak on a very important topic. And the conference is on the criminal justice system. Specifically, I have chosen the topic International Criminal Court because we can see that from past 5 years we've been going through a lot of wars like Ukraine and Russia. Then we are having war with other countries, Israel and Gaza, and another very all countries are somewhere or other ways are having some or uh, different issues with other countries, and they are having this because of this uh, certain kind of the problems which are historical, and then then they are not able to negotiate, and they're not able to uh, solve this issue, and then that becomes the war. And after war you can see that a lot of human right violations happens, and where there in this human right violation we can see that the role of international criminal court comes. But what happens in criminal court, it's the jurisdiction issues, then there are certain other issues like investigation process, and then they cannot engagement with the victims very easily because of the sovereignty issues with other countries. These are the challenges which we reason why international criminal court is not able to achieve the purpose for which it was established. And still we are seeing this, there are a lot of very few conviction has happened, and that is the reason why we have to reimagine the how we can make international criminal court more stronger, and also we can bring about the certain other emerging issues like cyber warfare, and ecocide is one of the issues which we need to brought into the international criminal court. And for that I have traced the history of international criminal court and the issues of sovereignties and other aspects, and how the court is prosecution, and then there are certain other aspect with reference to how their justice process is with the European countries, with the USA, and with the African nations. We can see there are certain bias and certain approaches which International Criminal Court is exercising. We have certain cases which proves that facts that when it comes to the case of African countries, that International Criminal Court becomes active. And when we see the cases with the European countries, or we can see the cases of US, this is something which I have argued with the certain references. Then there is a Rome Statute which governs the international criminal cases, that there are so many cases of that. And we can see that there are certain limitation of a jurisdiction in the international criminal court, and because of that limitation of jurisdiction which mentioned from article 5 to 3 of the Rome Statute, which talks about there are three ways we can exercise the jurisdiction. One is territory, another one is nation state, and another one is UNSC, which is there. But still, because of certain weak implementation, these are the certain aspects where which you are not able to achieve. Then there is a concept of temporal jurisdiction. Temporal jurisdiction talks about the restriction in certain aspect, where in specifically in a genocide crimes, we have seen this jurisdiction has been not been enforced in a manner. Then there is a role of UNSC, and we can see that in certain cases UNSC has played very important role in a Sudan Darfur case and in Libya. But what about the cases which right now happening with the Israel Gaza and all the other aspects which where is very lesser discussion is happening? Then there is a state cooperation is one issue, because we can understand that in a sovereign status and in the multipolar world, it's very difficult to convince the state to do certain issues, and that's the reason why we are not able to achieve the things because of sovereignty and other aspects. State cooperation is lacked, and we have already explained that neo-colonialism and African issues is there. Then there are certain cases of Palestine and Iraq, which has been seen from the different perspective. There are certain allegations of structure biases and prosecutional discretion from the ICC also, which I have already discussed, that how their decision making has influenced with the West and versus East and versus African countries. Then there are certain other aspects which we I have discussed. Specifically, Russia and China, they are having veto power, and that's why the reason that UNSC and ICC, there are certain conflicting problem. Now come to India. India is also concerned about the sovereignty and judicial independence, and that's why we are not. And see, we have seen one of the few incidences where ICC, that cases has been filed against uh, I think Narendra Modi in the case of this Godhra riots, but against they have cited this is a state failure, and that's a very internal issues that cannot be brought before ICC, but it has to be addressed to this. These are the certain examples where we can see that even certain aspects which ICC has limitation, and also when it comes to India also, there are certain sovereignty and judicial independence is one of the issues which I think. And one of the important aspect I have discussed, weak investigation I already discussed, bureaucratic concerns and resource constraint is also aspect, because of that budgetary allocation is also decreasing day by day, which is the reason why ICC is becoming more or more less effective than victim participation. And another approach I have also discussed. Now the important aspect is the emerging crimes like digital warfare, cyber atrocities, and ecocide, which has not been recognized by the ICC, because ICC only recognized four crime of crimes. In that ecocide is not included, and that is where I have also explained that why this kind of crisis and the things has not been covered within the framework of ICC. And these are the certain aspect where we have to reimagine that how we can make an ICC more effective, more enforceable, more enforceable, so we can also achieve the purpose which UN has, or even the whole peace thing was discussed. And otherwise, I think it will be very difficult to address these issues, and then there are chances that human right violation will be there, and these issues will be continue forever and ever. That's why that I chose this topic, and I have argued that certain issues like weak enforcement, jurisdictions issues, and specifically recognition of new crimes should be discussed, and that is where we can achieve the purpose of the International Criminal Court in achieving justice from the transformative perspective. Thank you.
Um, Thank you so much, sir, for that thoughts-provoking presenters. Next, we have a presenter in Karan Sejpal, a student from Christian to University, Pune, Lavasa. He will be present on criminal justice in India and beyond. Karan, Karan sir, the floor
Uh,
is yours.
Thank you so much, ma'am. I am Karan Sehajpal. I am a student pursuing BBA LLB from Christ deemed to be a University Lavasa campus, Pune. I am in my fourth year right now. Ma'am, I would like to share my screen. Do I have permission to do so? To present my PPT?
Yes, yes.
Thank you so much, sir. Is my screen visible, ma'am? Can you please just let me know this once?
Yes,
Your
sir.
screen is visible.
Thank you so much, sir. The topic of my paper is criminal justice in India and beyond. The topic of the conference revolves around the concept of criminal jurisprudence, which is a very intriguing topic, as this is one which is universal to every nation and every sector of society, regardless. Thus, it becomes a very interesting topic to analyze the jurisprudence of crime administration from a global perspective. When I was researching on the topic, I observed that even though there are various sources and papers available on the issue, no one single paper pointed out about the position of India as compared to other nations. So I took this as my research gap, and this paper is an attempt to let the readers know where India stands today in comparison to other nations. I begin my paper by giving an introduction to the concept of dharma, which is the origin of criminal laws from the ancient era. Dharma can be said to be the foundation of criminal jurisprudence in the ancient times, when there were no laws or any other governing body, and thus dharma was used as a sole guide to which one person is supposed to know what and how to do. It is this very concept which led to the formation of concept of right and wrong, which is universally accepted today. Further, I analyzed the Mughals and the English and how they used to treat criminals with respect to Indian subcontinent. In the initial parts of my paper, I focused on India, as before learning about the world. It is very important to understand about one's home. The next very important milestone is the independence. One question which bothered me was, why did uh, India, after independence, uh, decided to retain many of the colonial laws involving including major criminal acts. Then as we are aware about the introduction of new criminal regime in India, I focused on why there was a need for a change, and what benefits, if any, are these new laws bringing to the table. As we move further in the paper, my approach shifts from that of within India to a more international and a globalized one. I've tried to correlate various factors which affects crime rates, such as socioeconomic conditions, population density, and the policing of the area, and how these factors are universally applicable irrespective of the nation. Then, after pointing out the positive and the negative points of the new criminal laws, I analyzed the criminal jurisprudence of three broad justice administration system, that is the Nordic with special emphasis on Denmark, the Middle East with special emphasis on Saudi Arabia, and last but not the least, the Japanese. My reason for selecting these are that these all systems are unique, different, and represent the extremes, with Denmark being considered as one of the best systems, while on the other hand, there are some questions about the Middle Eastern systems. By analyzing all these systems, I was able to place India somewhere between them and conclude that India still has a long way to go. Thus, this paper this paper hits home, as I have some special inclination and interest towards criminal law and administration, and been an intern at various criminal law firms. I have also tried to put in my own experience and observations from the floor level of the um, courtrooms. And at the end, I would like to thank the entire. Sorry. At the end, I would like to thank the entire um, uh, organizing team of Central University of Karnataka for providing me with this platform of presenting my paper. Thank you so much.
Thank you so much, sir. I'm audible? Hello, I'm audible.
Yes, ma'am.
Okay. Thank you so much, sir, Karan sir. Now I would like to call Dipin Valve sir and Sona. The title of the paper is Beyond Borders, Beyond Reality, Legal Responses to Cybercrime in the Metaverse. Sir and ma'am.
Good afternoon, all. I'm Sona Varghese. Am I audible?
Yes, ma'am. Are you audible?
Okay, good afternoon, all. I'm here to take my seminar on the topic Beyond Borders, Beyond Reality, Legal Response to Cyber Crimes in the Metaverse. Let me start with an introduction. The term metaverse has translated its science fiction origins to become a focal point for the technological and social development, envisaged as an embodied internet where users can interact with each other and with digital objects in a three-dimensional persisting space. Platform like Decentraland, Roblox, and Meta Horizon World are yearly prosecutes to these features. This evolution from a two-dimensional web of pages to the three-dimensional web of places creates immense opportunity for commerce, education, and social connection. However, where humanities goes, its conflict and vice fellow. The very futures that meets the meta-wise compelling immersion, persistence, anonymity, and the use-generated economics also rendered it a fertile group for novel and adapted forms of criminal activity. A new criminal landscape typology of metaverse crimes. While the concept of cybercrime is not new, the metaverse unique character of impression, persistence, empowerment, and decentralized economic fundamental alter the nature and magnify the impact of illicit activities. Crimes are no longer confined to data theft from the static database or harassment on the flat social media feeds. They are enacted in three-dimensional persistent space by avatars that serve as direct extension of their user's identity. First one is economic and property crime in the virtual economy. The integration of real world finance through cryptocurrencies and non fungible tokens has transformed the virtual world in a bustling economic ecosystem. Where there is a value, there is a crime. Theft of digital assets. This is the most direct parallel to real world theft. It involves the unauthorized acquisition of valuable virtual property, including NFTs, unique digital assets represented art, collectibles, or branded goods. Virtual real estate. Piles of land in the platforms like Decentraland or the Sandbox, which can be worth millions of dollars, platform currencies, and rare items. In words, currencies or rare tradable items, characters like skin accessories, tools that have significant market value. Methods of theft branch from traditional phishing attacks and social engineering, tricking users into revealing their crypto wallet credential to Spotify exploits of the vulnerability in the smart contract. Fraud and market manipulation, reg pulls, pump and dump schemes, fraudulent representation, money laundering, placement, layering, integration. The second one is crimes against the person and avatar integrity. The use of avatars as embedded representation of the self means that attached with the meta voice can inflict genius, philosophical, and emotional trauma, blurring the lines between virtual and real world harm. Virtual harassment, assault, and hate speech. This goes for beyond text based trolling in the meta voice, it can evolve. Embedded harassment, using one's avatar to physical block corner or intimidate another user's avatar. And the third one is data privacy and infrastructure crimes. The technology underpinning the metaverse is a source of underprinted data collection, creating new vulnerability for individual and the platform themselves. Unlawful biometric data harvesting. VR and AR hardware does not just like what you do, it tracks who you are. This technology can collect highly sensitive biometric data, including eye tracking and pupil dilation, revealing focus on emotions and response, voice pattern and intonation, gait analysis, and unique physical mannerism, potential even EEG data, brainwave activity, and the jurisdictional comma whose law applies in the metaverse. The single most formidable obstacle to establishing law and order in the metaverse is the problem of jurisdiction. Jurisdiction is the legal power of a court or state to hear a case and enforce its law. In the physical world, this power is fundamentally anchored to geography. First one is the breakdown of the territoriality principle. The bedrock of criminal jurisdiction is the principle of territoriality. A nation has the primary right to prosecute crime committed with the physical borders. The central concept is the delicate location where the crime took place. In a
Sorry,
simple
we
case of
interrupt you, ma'am. Please conclude your topic. You have only 1 minute left.
okay, ma'am. Okay, let me conclude my topic. The metaverse presents a radical reimagining of digital interaction in immersive persistence and borderless domain where the boundaries between the physical and virtual content blur. While it opens new vessels for communication, commerce, and creativity, it simultaneously connects a fertile group of cyber crimes that transcend traditional legal categories and jurisdictional boundaries. This evolving fortune challenges the competence of existing legal regimes to effective depths. As we move beyond borders and beyond reality, the law must follow not beyond but alongside ensuring that the promises of the metaverse does not become its peer. Okay, thank you all the organizers for giving me this opportunity. Thank you.
Thank you so much, ma'am, for your engaging presentations. So our next presenter is Jinesh Sir, Assistant Professor of Law, School of Law, Vistas, Chennai. He will present his paper titled Beyond Borders and Bytes, Reimagining Criminal Jurisprudence Thought Through Technological Micro-Narratives and Global Meta-Narratives. Mr. Jinesh, sir, you may proceed.
Thank you, ma'am. Am I audible to you?
Yes, sir.
Am I audible? Yeah. Okay, thank you, ma'am. So, good afternoon, everyone. I'm here to present the paper, and I would like to share my presentation here. So, do I have the permission to share my screen? Hello?
Yes, sir. Yes, sir. It's visible.
Is it visible? Yeah.
Yes, yes, sir.
Fine. Okay. So, my the topic of this paper, or the title of the paper, is Beyond Borders and Bytes, Reimagining Criminal Jurisprudence to Technological Micro-Narratives and Global Meta-Narratives. So, since I have just 8 minutes, I'll just concisely, I'll just present it. So, with this first slide, the evolving landscape of criminal law. The 21st century has seen a fundamental transformation in criminal law driven by globalization and new technologies. And the traditional legal frameworks, once confined by borders and paper, now operate within a digital ecosystem that transcends national boundaries. Which means we know that there is an evolution of criminal law since from the ancient time onwards. And when we talk in terms of the modern time, the globalization has given a big impact on the evolution of the criminal law. And when we take the example of India, here from 1991 onwards, because of the economical reformations, there were a lot of new things came to our country, and also the markets were open to the other countries, and we had this integration of markets towards every other foreign countries, which actually paved the way for many of the expansion of criminal law to such points where the criminal activities related to that also increased. So there should be a technological shift that should be enabled in order to bring these two things, the meta as well as the minor things as well as the meta thing. If this needs to be connected together, there should be a technological shift, and it involves digital evidence and cybercrime, which actually redefined investigation and prosecution. So technology is the key thing that actually joins the two sectors here, that is from micro narratives to meta narratives. And it has got a lot of new challenges, like the jurisdiction problem will be there, which means the conflict would arise in terms of the jurisdiction, and also the sovereignty, the concept of the sovereignty will also be, there will be some kind of shift there, and also the individual rights associated, it will be reshaped. So this is the first concise form of what my presentation actually deals with. And from the micro narratives to meta narratives, we'll first handle this micro narrative. What do you mean by this micro narratives? It is actually the unique stories of individual criminal cases confined to specific jurisdiction and time period. So these are the very small kinds of individual criminal cases that is happening in a particular specific region or specific time period that is actually confined to a jurisdiction and things like that. And here the meta narratives, it is actually the overarching patterns that integrate various cases, jurisdictions and technological components into global criminal trends. So this is actually, the meta narrative is actually at the wider sense of how this criminal activities are being seen. And the micro narrative is actually the specific, a very small kind of, a small space within which how it is being seen. So from the micro to the meta, these are the two things that is happening here, and the technology is not actually connecting both the micro narratives and meta narratives according to my paper. And the next thing is about the technology, which is the core of evolution. The technology is pivotal in this narrative shift, enabling the collection, analysis, and connection of work data to transform single criminal events into parts of larger global patterns. So here, since after the globalization, there were a lot of discussions on various technologies like digital forensics, the artificial intelligence, of course, and the international databases and the communication tech. So here, when the globalization is happening and the integration of economies are also happening, a lot of the criminal activities will also be hyped and also it will expand. So at that time, the forensics, whatever the conventional way of forensics are being there, the technology should be infused into it, and there are a lot of ways in which the uncovered evidence from digital devices and online activities can be done with the help of this technology. And also, of course, with the artificial intelligence, we know regarding how it is actually helping the criminal jurisprudence, not only just in our country and also the entire world. It actually recognizes certain patterns and predictive analysis for law enforcement. So artificial intelligence is also doing some new thing on the criminal jurisprudence here. And also the international databases, which means the access to the international databases is also a very important thing, which actually crucial when it is shared within the countries altogether or across the borders for coordinated efforts. That will also bring the technology to infuse into the criminal justice to achieve the actual goals regarding to that. And also the communication tech is also another important technology that should be enhanced, where the real-time coordination among global agencies, different kinds of agencies like RAW, CIA, KGB, MIA, all these international agencies they are coming together, and the communication among them is a very important thing. And also the technology which actually helps them to communicate in real time is a very important thing here to minimize the distance between the micro and the meta narratives here. And the case studies, technology in practice, I'll just we'll go fast. The first one is cybercrime networks investigations like the Silk Route, the darknet, things that is the financial things, a lot of dark financial transactions that are happening in the world, and also the WannaCry really intricate, that is about the ransom. And all these global operations can only be done by these agencies with only a better technology that can be infused into this different situations. And also it helps in the counter-terrorism, integrating the intelligence, all this kinds of agencies. They have
Sorry
no-
to interrupt you, sir.
Yeah,
Please conclude
Yeah.
your topics.
I'll get. So, conclusion is actually the balancing progress and principles. The technological evolution of criminal law offers immense opportunities, but demands a careful balance between effectiveness and human values. When the technology is actually infused to bring this distance, to minimize this distance between the meta and the micro, there are a lot of other challenges, including the privacy, related to the privacy, and also a certain other related things will also be an important thing that should be considered. And the opportunity, more effective and comprehensive justice approaches should be done by all the countries together, and the responsibility ensure new rules on our human dignity, protect rights, and foster democracy and foreign effect. That should be the goals that they have to achieve. The future of criminal law hinges on how we will integrate technology while upholding justice, fairness, and individual rights. So at the end of the day, what we are actually trying to uphold is the justice, the fairness, and to honor the individual rights. So that is all about my presentation. So thank you so much, everyone.
Thank you so much, sir, for your engaging presentation. So we have a next presentation, Mr. Sakib, sir. He's a research scholar and he's a research scholar, School of Law, University of Kashmir, and co-author is Dr. Iftikhar Hussain Bhatt, sir. And the paper title is The Role of the Indian Judiciary in Addressing Environmental Crimes, a Study of Landmark Judgments. Sakib, sir.
Hello.
Yes, sir.
Audible.
Yes, sir. Yes, sir. You are.
Is my screen visible?
Yes, sir.
Yes, yes,
Screen,
sir.
yes, sir. Screen is visible.
So, a warm good afternoon to everyone who is present in this session. So, I am Sakib Ayub, a research scholar from School of Law, University of Kashmir. Today, I will be presenting a paper titled as The Role of Indian Judiciary in Addressing Environmental Crimes, a Study of Landmark Cases or Landmark Judgments. So, without wasting any time, I would go on to the introduction. First, we will see what is actually the environmental crimes. Environmental crimes simply means, in simple words, it means activities violating environmental laws causing harm to ecosystem, biodiversity, and human health. In other words, it can be said these are the illegal acts that's harmful for ecosystem, wildlife, and public health. For example, pollution, deforestation, and illegal mining. So coming on to the role of the judiciary, we have a constitutional courts whose primary role is interpreting constitutional provisions. Judiciary, via the active intervention through PIL, constitutional interpretations, and enforcing environmental laws, has a crucial role while protecting or conserving the environment. While delivering on its role, the provisions, the constitutional provisions, and there are another environmental laws that are used actively by the judiciary. Judiciary, under Article 21, has carved the right to healthy environment in rural litigation, the entitlement Kendra versus state of UP. Judiciary actively uses Article 48A and 51AG, which talks about directive principles of state policy and fundamental duties that are on the citizens of India in order to protect and conserve the environment. There are various other environmental laws such as Environmental Protection Act, Water Act, Air Act, Wildlife Protection Act. I could only name few. There are others also like NGT Act, Forest Rights Act, Indian Forest Act, and others also. So, coming on to the landmark judgments, what are the judgments in which the environmental crimes has been addressed? First one is MC Mehta. I have only listed 6 of them, though in my paper I have mentioned more judgments. I will only talk about in this presentation only 6 cases. First is MC Mehta versus Union of India, popularly known as oil and gas leak case. As a result of this gas leak, it resulted into the air pollution as well as harm to public health, risk to life due to hazardous industrial operations. In this case, court carved out, Justice Bhagwati carved out the principle of absolute liability for hazardous industries, as the earlier principle, that is the principle of strict liability, has had many exceptions through which these industrial occupations, operations took exemptions of those exceptions. Second one is Vellore Citizens Welfare Forum versus Union of India. This case is related to discharge of untreated effluents by tanneries into agricultural lands and water bodies in Tamil Nadu. In this case, the court recognized precautionary principle. Better is to stop at the initial, and also recognized the polluter pays principle. One who pollutes the environment has to pay the amount to reverse the effect that he has caused on the environment. It acknowledged those principles. In another case, there is the case of Subhash Kumar versus State of Bihar. It is the pollution of Bakura rivers due to industrial waste from the Tata Iron and Steel Company. In this case, the court decided that right to pollution-free water and air is a part and parcel of Article 21. The other cases are MC Mehta versus Kamalnath. It's a case of encroachment and diversion of these rivers by spam motors for private commercial use, which resulted in the alteration of river courses, damages the river ecology, and flood risks. It resulted into the Justice Kuldeep Singh carved out the doctrine, that is the public trust doctrine, applied for protecting the natural resources in India. Then we have another case, that is TN Godavaram Thrumpalad versus Union of India. It is case related to illegal deforestation and misuse of forest land for non-forested purposes. In this case, court ensured through various guidelines that there should be forest conservation. Another case is Indian Council for Enviro Legal Action versus Union of India. It is the case related to hazardous waste, chemical wastes by chemical industries in the small village of Rajasthan, through which soil and underground water got contaminated. In this case, polluter pays principle was again acknowledged by the Supreme Court of India. So one of the recent case study is of the Kancha. It is related to Hyderabad, Telangana, where there was deforestation of forests for the development of IT park. Supreme Court in this case took sumo to action and stayed the process of deforestation. They were cutting down the forest in order to build the IT park. So Supreme Court stayed this action of the government. In conclusion, I would say no doubt there are certain challenges with respect to these judgments, that is with respect to judiciary, that is delayed justice sometimes, cases burdens. There are lots of cases pending in the judiciary, weak enforcement of the orders, and lack of special knowledge sometimes if the case is not in NGT, limited penalties. In conclusion, I would like to say that through these cases, we can get an idea that judiciary somewhat acted as a guardian of the environmental rights in India. These landmark cases have shaped the environmental jurisprudence in India. There is a need for development, balance between harmonious construction, I would rather say, between development and conservation. And in future, we will say that there is a need to strengthen National Green Tribunal, improve compliance mechanism, weak enforcement orders should be addressed, and enhance community participation so there can be conservation of the environment. So with this, I would like to conclude.
Thank you so much, sir. Thank you so much, sir, for engaging in your presentation. Now, I would like to call Mr. Divakar, sir. Due to some technical issues, he did not complete our presentation. Hello.
Hello.
Mr.
Ma'am,
Divakar, sir.
am I audible?
Yes, sir. Yes, sir. Yes,
Yeah,
sir.
yeah. Thank you,
Yes, sir.
madam,
You
for
can
being
continue.
present. Yeah. Right. First of all, I'm sorry. At the time, there were some technical glitches due to which my connection got lost. So, myself, Dr. Divakar Sharma, I'm an assistant professor in the Department of Juridical Studies, Mahapurush Srimanta Shankardev Vishwavidyalaya, and I'm going to present the topic that is selective justice and international criminal court or study. So, before going into the topic, let me speak about some of the synopsis backgrounds of the topic. That is, first of all, we'll going with the introduction and with the objective and research methodology. And second, with the concept of selective justice in the International Criminal Court. Third is the International Criminal Court chooses to development of the justice. The development has been divided into 4 parts. There is the embryonic stage, formation, practical, and regulatory stage. Then factors influencing the selection of justice by the International Criminal Court. Here I have divided it into 3 parts. There is the choice of legislations, the choice of law enforcement, and choice of the country. And finally, with the conclusion. Now, coming to the introduction, the entry into the force of the Rome Statute of International Criminal Court as the establishment of the ICC is important symbol of improvement and development of the international criminal law system. The international community has criticized the selective justice of the International Criminal Court, especially African countries, which has expressed strong dissatisfactions. Now, coming into the objective, the researcher has formulated 2 objectives. That is, first, to study the judicial selectivity of the International Criminal Court. Second, to study the legislative actions of the selective justice by ICC. And moving into the research methodology, the researcher has purely used doctrinal method to write this paper, like books, X case studies, etc. Now, moving into the concept of selective justice in the International Criminal Court, in the recent selective justice has been directed at the African leaders. So enforcement of the international criminal law has been more selective than enforcement by domestic courts. Selective justice refers to a system in which when a crime is committed in a country or region, the judicial authorities will make different treatment according to its specific circumstances. According to the Chinese and foreign scholars, the selective justice of International Criminal Court covers a series of selective acts, including but not limited to treaty making, discretion, the United Nations Security Council, and the state contracting, etc., which have a certain impact on the operation of the international criminal system. It refers to a set of rules and mechanisms based on the jurisdiction in the field of international law. In the International Criminal Court, the discretion of the judges and prosecutors leads to selective judicial actions. Now, moving on to the International Criminal Court chooses the development of justice. First stage is the embryonic, means the beginning of the stage. At the end of the World War II, the establishment of the Nuremberg, Tokyo, and ICT-wide tribunals, as well as the Rwanda tribunals, injected targeted judicial suits into the field of international criminal justice. Prior to the Rome Statute, the subsequent establishment of the International Court advocates the international criminal justice, where increasingly concerned about the judicial selectivity involved in the arbitrary creation of the single conflict tribunal. Since these international judicial bodies were established in the context of selective justice was seen in its infancy as a criticism, whether well-intentioned or ill-intentioned, and has a difficult problem for the ICC for its inception to the present day. So the main feature of the sprout of selective justice is that it does not conform to the principle of neutrality and non-discrimination, which has become the biggest obstacle of its development. Now, then come to the formation stage. In 1994, the draft Rome Statute of ICC was introduced. In 95, the United Nations started the preparatory committee of ICC. And finally, in the 1st July 2002, 60 countries ratified the Rome Statute. Now, in the practical stage, in the beginning of the case, when it took its adjudication process in January 2016, the pre-trial chamber, at the request of the prosecutor, authorized it to investigate the situation in Georgia. However, as the situation investigated by the prosecutor were all African countries, there were voices criticizing the prosecutor for selectively administering justice to African countries. Although the claim was supported, it also raised some doubts. The disappointment of the African Union with the court and the United Nations Security Council mainly stems from its belief in the politicization of the international criminal justice. As a result, the UN Security Council was authorized by the Rome Statute to submit cases of suspected international crimes within the jurisdiction of the International Criminal Court to the court, while the transport of the Security Council extended to the court's jurisdiction to non-contracting parties, including referring to the situations in Darfur, Sudan, Libya, to the court. African countries account for the vast majority of investigations and prosecutions by the ICC, regardless of the contracting situations. Now, coming out to the choice of legislations, the factors that are influencing the selection of justice by ICC, the establishment of the ICC is based on the Rome Statute, which is a universally adopted form of international treaty-style legislations of international law, among which the most important legislative principle is the principle of legality of crime, which for the first time explicitly stipulates the principle of legality of crime in form of the international criminal legal documents. Now, if you come to the choice of law enforcement, in the statute, the ICC has adopted a unique organizational structure that organically combines judges and prosecutors to form a unified law enforcement system, making the relationship between judges and prosecutors both independent and irrelated. Now, coming to the choice of the country, the political choice to accede to the statute is different from the political choice of the Security Council, because the Council influences the selective justice of International Criminal Court through legal means, while states can only rely on the diplomatic means, which is the selectively of the national interest based on national sovereignty, and thus affects the selective justice of ICC. So thus, concluding the paper, the researcher says that selective justice has existed in the ICC since its establishment and has gone through 4 stages: germination, formation, practice, and regulation, and has shown different characteristics of selective justice.
Sorry to interrupt you, sir. Please
Yeah,
conclude your
finishing,
topics.
yeah.
Okay.
The International Criminal Court is mainly affected by the factors of legislation, law enforcement, politics, state contracting, etc., resulting in 2 aspects of active and passive selective justice theory. As a result of these factors, selective justice in the ICC has often led to practice to situations that undermine state sovereign, question national judicial system, and target non-state parties. Thank you. Thank you, the organizers, for letting it present. Thank you.
Thank you so much, sir, for your presentations. Now, thanks to all the presenters for your thoughts-provoking insights. I would like to request the chairperson, Professor Jeeva ma'am, for enlighten this session to kindly share their views.
Thank you very much, moderator. I want to ask you that is there any time for the discussion or that, give the chance to the audience to ask the questions, or can I directly go? Now
Yes,
we
ma'am.
can.
Yes, ma'am. After enlighten the session, after that we have a panel discussion.
Okay. So we have that our session is technical session. Our technical session is global perspectives of criminal jurisprudence. And first, I would like to thank each and every one of the presenters who focus on some of the cross-cutting edges in the criminal jurisprudence today. Some have discussed the international criminal law perspective, specifically focus on ICC, some of the issues that are pertaining to ICC. So I also would agree to say that yes, the selective, the countries, the selective jurisdiction mechanism is one of the issues that not only the Africans say that, even that the South Asian region of some countries are suffering from that. The special selections to come behind. And even though thanks to Pramato and the complementarity, but I see that the discrimination is there. Then the other one, when it comes to the second, speaker, he also focuses on the same thing, but special reference to how that we can, where that ICC should focus on to improve. Then, the third person considered that the criminal justice in beyond, and it's beyond that. focusing on, and it is very, I mean, interesting to hear that Dharma is the foundation of Indian criminal, the jurisprudence. Yeah, that I also see the similar, the version when it comes to Sri Lanka. We also see the same thing. So then that is the very the important idea I have taken out of the third person. So then the fourth person went discuss on the cyber crimes, talking about that how it goes beyond the boundaries. He came with, he or she, I can't remember, I'm sorry, came with the important things. But I really want to focus with you the data protection and issues pertaining to that, because today there is a big issue in relation to the protection of the data. So then when the data is, it is freely available, so there are a lot of issues can be arisen. So because of that reason, what would happen is people, even people's life is also in danger. So therefore, I want to say that this in that sense, that paper is very much interested in. So I'm talking about only the positive sides, but I think each and every paper has the negative sides also. But I would like to discuss only with you the most eye-catchy and interesting points that I have taken out of the presentations. So then the other one is beyond the fifth one, beyond borders, beyond reality. So then here I really wanted to point out that so it considers that, you know, considering how that it is shifted from one into the other, and then thereafter what are the challenges that encounter today. So then that is therefore the technological shift actually, I mean, created a lot of issues today, especially when it comes to evidence collection and thereafter submission of the evidence. Then when it comes to evaluating, and these are some of the issues that I see when it comes to this the technological shift in the criminal jurisprudence. When we see that the technological shift and as some of the challenges which are pertaining to that. So then the sixth one is very interesting to me, because this is one of the very favorite areas, that is environmental crimes. They are actually, it's very correctly pointed out, there are a lot of the new avenues that you can see that the environmental crimes are taking place. But to my view, when it comes to the protection of the environment and with the sanction, kind of a sanction, whether it is possible, because there are lots of the international instruments, but I can't see that, you know, the sanctions are there. And when it comes to the presenter focus on the Indian perspective, but the other countries also, we also have the same things. And what we can do, should do, is we have to identify the offenses and see that how we can really, what kind of the meaningful sanction. It is not merely send a person to jail or that getting something back. So then how you can use the concept of polluter pays, that concept when it comes to, I mean, introduce new the improvements to environmental crimes. So then the other one, yes. So then the next one I have, yeah. So then there are, these are the 7 presenters, sorry, 6 presenters who came with their new ideas. But I would like to just, you know, conclude saying this. When it comes to the, my perspective is just, you know, to cover that our technical session, the global perspectives, where that, you know, the other the students are here listening to that, to consider the global perspective starting from defining crimes. So then identify that the technological crimes as very clearly understood, I mean, identify environmental crimes and as well as the economic crimes. If there is no definition, there is a problem. So then when it comes to globalization, it is not, we can't really, confine only to the jurisdictional wise. We have to think of that, how we can go beyond that to come with the universal type of definitions for the unconventional crimes. So unconventional crimes means according to the development of the society and based on the necessities and the needness of the people. So then some crimes are emerged. So how we can come with the definition? On the one hand, with regard, to apply that in the local standards, and on the other hand, the international standards. There I would like to just give a kind of an eye, technological crimes, environmental crimes, and economic crimes. One example, corruption. It's very difficult to define that, enabling all of us to come to the kind of a conclusion where each and every country can agree to that. So that is one aspect. The other aspects, once we identify the different crimes, so then we have to have a mechanism starting from, as our plenary session, the third speaker spoke on that, the criminal procedure. So then the criminal procedure also always, the internal criminal procedures should be linked with the international and at least transnational to, the level. Why this is? Because today we can see that transnational crimes, the international crimes. So then one person can stay in one place and commit a lot of crimes affected, that may be affected by the people in the different other countries. So therefore, so when it comes to the procedure, we have to consider that how globalization and cross-border crimes. So we must consider rise of transnational crimes and jurisdictional struggles to adopt domestic laws to effectively address crimes and the transnational borders. And thirdly, I would like to say that under the globalization and cross-border crime is concerned, need for robust international legal frameworks, cooperation mechanisms like Interpol, UNODC. UNODC, though we have the 3 protocols, but still we must look at that, how to improve that, enabling the entire international community get kind of a benefit out of that. So then the next aspect that I want to very briefly tell you that the human rights integration in criminal justice system, that is also should be considered as a kind of an aspect in the global perspectives of criminal jurisprudence. So there we must look at that the challenges include ensuring fair trial, rights, prohibition of torture, and safeguarding minority rights. So then when it comes to torture, actually we have, to my understanding, we discuss a little bit, further. But when it comes to fair trial, but on the perspective of victims' rights, there are a lot of the areas that we have to consider, including victimology as well as restorative justice. Because when it comes to crime victims, their rights, their participation are not that much recognized in many of the jurisdictions, and we have only one declaration. But I know that ICC also compensation is included, but we have to do, lot more to be done. So therefore, these are some of the areas, my dear students, that you can focus on. It is in my view, in global perspectives of criminal jurisprudence, we have to focus on that as well. So then the minority rights is another aspect that we have to consider, especially the indigenous rights, how that in the globalized, the economically developed world that we are considering only the economic development rather than forgetting the social development and the environmental preservation. So there are, most of the times, the indigenous people are marginalized. Therefore, it is another area that we have to look at. So then, and the other one, we are discussing that, but we have to consider in a very the smooth manner, where a lot of the international politics is involved in this area. That is balancing state sovereignty with global human rights norms, and it is a kind of the complex issues that still remains. So that is one aspect we have to think of it. The last one is collaborative strategies and capacity building, including law reforms and focusing the modern challenges. There, I think that you have done, you have improved year before last, all that the criminal law related, the main, the statutes.
Sorry to interrupt you, ma'am. Please.
I will conclude that. So then, therefore, to consider that how we can come with the new law reforms. They are not only considering the different types of crimes, consider that how the new how that the evidence law can be incorporated to fit it into the modern the trends. And lastly, I want to take want to focus your aspect with regard to the victim support and the how we can come with the robust sentencing policies. These are some of the aspects that I think that we have to focus on when it comes to the global perspectives of criminal jurisprudence. Thank you.
Thank you so much, ma'am, for your valuable contribution and insightful knowledge. Your expertise and perspective have greatly enriched today's session, ma'am. We are truly grateful for your times and efforts. Now, I would like to call Co-Chairperson, Dr. Jayanta sir. Please invite the session.
Yes. Actually, first of all, I would like to extend sincere congratulations to all the participants that in this technical session, all of them, that means 100% attendance we have achieved, and it is because of you all. Second, I'd like to thank Jeeva ma'am for coordinating this session and sharing this session in such a manner that we have learned a lot. I personally learned a lot from her. As regards the concluding remarks are concerned, I think this session has been a very successful one. Specifically, I'm not the right person because the co-chairperson was Matolli sir. Unfortunately, he met with an accident, he's hospitalized. So I took this position anyway. Since I am from the organizing committee, so I cannot provide any specific concluding remarks on your papers. But one thing I would like to mention, that little bit methodology aspect for arriving at your conclusions, what you have mentioned in the presentation could have been done. Maybe this might have been addressed in your papers. Otherwise, all have done a very wonderful job. I extend my sincere congratulations for presenting your thoughts and making this session a very really meaningful and valuable one. We hope that you will be joining with us for a few next sessions also. We have a plenary session followed at 12 p.m. and then technical sessions. We are very much hopeful for your attendance. Thank you.
Thank you so much, sir. Now the panel discussion is now open for only 2 minutes. If any participants has any query, so you can ask. You can put your question in the chat box or unmute yourself. We can ask.
I think there is no questions. You can please call upon for a vote of thanks.
Yes. Okay, sir. So to conclude this intellectual enriching session, I now invite our session coordinator, Mr. Shaikat Ghosh, to kindly deliver the vote of thanks.
Thank you, Ms. Meenakshi, and good afternoon, everyone. It is my privilege and honor to deliver the vote of thanks of this enriching and intellectually stimulating session, Global Perspectives of Criminal Jurisprudence, organized as a part of our academic conference by the Department of Law, Central University of Karnataka. First and foremost, I would like to express my deepest gratitude to our chairperson, Professor Jeeva Niriella ma'am, and our co-chairperson, Dr. Jayanta Borua sir. Thank you, ma'am and sir, for your gracious presence, keen observations, and thoughtful feedback that added depth and direction to this session. My sincere thanks to our moderator, Ms. Meenakshi ma'am, for seamlessly guiding us through the presentations and maintaining the decorum and academic flow of this session. I extended my heartfelt appreciation to all our paper presenters who brought forward a wide spectrum of ideas. Each presentation has added immense value and sparked important questions and reflections. A special word of thanks of our reporter, Mr. M.V. Ramanna Murthy sir, For documenting the proceedings of these sessions with care and diligence, I would like to acknowledge the efforts of the organizing team of the Department of Law, Central University of Karnataka, whose hard work behind the scenes has made this session possible. Your coordination and commitment deserve high praise. Lastly, I thank all the participants and attendees for their patience, active engagement, and for being part of this academic discourse. Your presence and interest contribute significantly to the success of sessions. With this, we formally concluded this technical session 1A. Thank you all once again, and I wish you a fruitful continuation of the conference ahead. Now, I am requesting Ms. Meenakshi ma'am to officially terminate this technical session. Thank you all once again.
Thank you so much, Mr. Secretary. Now I conclude the session. I sincerely thank our chairperson, co-chairperson, all presenters, attendants, and organizers this session showcase rich and insightful perspective on global perspective of criminal jurisprudence. Thank you all for your participation and academic enthusiasm. Thank you once again. And now you can join 2 o'clock in plenary session 2. Thank you so much, ma'am. Thank you so much, sir.
Thank you, Dr. Jan, and thank you very much for everyone. All the
Thank
best.
you, ma'am. Thank you, ma'am. Nice seeing you.
Thank you, ma'am.